see and hear the panel?
Yes, Your Honor. Yes.
We can't see Mr. Weiner. There we go. Great. Our next case is A182442, 21st Tobacco and Vapor Retail Association versus Multnomah County. Ready for the argument?
Good afternoon, Your Honors. Counsel, may it please the court. My name is Tony Aiello Jr., and I represent plaintiffs in this matter. This case presents three issues. The first is preemption of defendant's local tobacco retail license. The second is preemption of Ordinance 1311, which bans flavored nicotine products in Multnomah County. And the third is whether Ordinance 1311 is outside of county authority pursuant to Article 6, Section 10 of the Oregon State Constitution. I'd like to spend most of my time focusing on the first issue because I believe our arguments get stronger without defendant having its own licensure. But before I do so, I'd like to spend a little bit of time on a case called Schwartz, which this court decided last year in May. That decision potentially bears on the second question in this case, but not on the first question. As this court may also know, the Oregon Supreme Court accepted review of Schwartz in January, and so there's some ongoing issues there. But having now had the opportunity to argue this case, not once, but twice now before this court, similar issues, this law, I want to make a couple things clear for the court. The first is that my clients do not assert that local public health authorities have no ability to pass laws affecting nicotine products whatsoever. My clients do assert that the county does not have plenary home rule authority that it had before Senate Bill 587 due to the state's licensure. My clients also assert that ORS 431A.218 subsections 2A and 5A place limitations on what local public health authorities can do. The second thing is that no party in this case has asserted that Ordinance 1311 regulates certain ingredients in nicotine products. All parties agree that Ordinance 1311 prohibits conduct, specifically the sale of flavored nicotine products. If defendant's local tobacco retail license is preempted, then this case is like Schwartz, and plaintiffs would ask that the court consider those issues which are raised in Schwartz. If defendant's local tobacco retail license is preempted, that means that defendant will be doing the same thing that Washington County was doing in Schwartz, which is prohibiting conduct that is expressly licensed by a statewide, state-issued, shall-issue tobacco retail license. So turning to the first issue, which is defendant's local licensure. ORS 431A.218 subsection 7 plainly and unambiguously expresses the legislature's intent to preempt and disallow local tobacco retail licenses, except as provided in ORS 431A.220. The statute starts by saying, except as provided in ORS 431A.220, a city or local public health authority may not require a person that makes retail sales of tobacco products or inhalant delivery systems hold a license. The sole exception to that preemption is in ORS 431A.220, which plainly requires two prerequisites in order to maintain local licensure, both of which must have been met by January 1, 2021. They are also connected by the conjunctive and, meaning both must have been met. The first is that the local public health authority must have required retailers selling nicotine products to hold a license. That's not at issue in this case. The second one is that the local public health authority must have enforced, I'm quoting here, quote, enforced standards described in ORS 431.218 subsection 2A. And directing this court to the record in this case, excerpt of record 145 is an intergovernmental agreement entered between Multnomah County and the state of Oregon. That says, quote, the county agrees to enforce standards described in section 17.2A That's ORS 431A.218 subsection 2A. Against persons licensed or otherwise authorized by the county under section 18, which is ORS 431A.220. So not only do we have the statute plainly saying that those two requirements must be met, but Multnomah County has expressly agreed with the Department of Revenue to do so. The trial court completely read out the second requirement and gives no meaning to the legislature's use of the past tense enforced, and also gives no meaning to the legislature's express citation to ORS 431A.218 subsection 2A, specifically the standards described there. Meanwhile, plaintiff's reading gives effect to all the language used by the legislature. The court's analysis should focus on what are the standards described in ORS 431A.218 subsection 2A. There, the state standards described are number one, the standards in ORS 431A.218 subsection 2B, and then the qualifications in ORS 431A.198. There's no dispute in this case that defendant did not, by January 1, 2021, enforce the qualifications required by ORS 431A.198. The trial court agreed, defendant agreed, and plaintiffs agreed that they didn't meet that requirement. Instead, the trial court and the defendant argued that those qualifications simply did not apply. The trial court described it as a fortune-telling requirement, saying that you must have known months and months prior to the passage of Senate Bill 587 that those would be the qualifications required by the state. Neither the trial court nor defendant cited any provision of law that would prevent the legislature from doing so. Instead, the trial court ignored the plain text of the statute and decided based on legislative intent. The court did not.
Legislature, I mean, given the clear evidence that the legislature wanted to have some of these local programs survive, why would it have essentially killed them by imposing these standards?
Absolutely. So first, in the legislative history, we don't see any evidence of the legislature sifting through the various programs that were already in existence to make sure that they all checked the boxes. Instead, the state set a minimum floor, and it's a very, very minimal floor. Specifically, it requires that localities not allow tobacco sales in areas zoned exclusively for residential use, and does not and requires that licensed locations be fixed and permanent. That's it. So it's not a long laundry list of requirements. The way plaintiffs see this, Your Honor, is that it's a filter. The state is setting very, very minimal grounds, and basically giving up power over the ability to enforce those minimal standards. So, and qualifications. And so by doing so, they're saying any who met this bar prior to January 1, 2021, they survive. Any who do not survive. So that's the legislative purpose that plaintiffs see behind it.
So are you arguing that not only would those conditions have to be included in the local plan, but also they would have had to be enforced against someone in the past?
So not exactly on the second issue. Defendant already had a local tobacco retail license, so they would have had to have been enforcing those, yes. But again, they are very, very minimal standards that must have been required. And I'm not sure if the legislature just thought that most of the programs had that. But what we don't see is in the legislative history is the legislature going through and making sure Multnomah County or other counties met that. They set their standard, they set their bar, the plain text says it, and we can't just avoid the plain text because Multnomah County doesn't meet it. And that's essentially what the trial court did, is said, well, that must not have been what the legislature meant. And if that's not what the legislature meant, the legislature and go back and change the statute, but that's what the plain text says. Regardless, though, in context, I think it makes sense that if the state is setting these minimal standards, that they would want before they give up power to make sure that any of the counties that maintain their own licensure enforce these 2, 3 minimal standards before they cede that power over. Any further questions, I will stop here.
My understanding is that the entering brief response that the programs were created for different purposes, that the local public health plans came about basically for health and safety, and the Department of Revenue plan was for something else. Is that correct?
I don't see that in the record. I see the big concern over wanting to have statewide licensure was for public health and safety. I would say that the goals are the same between the local public health authority and the state.
Thank you, Mr. Weiner.
Good afternoon, Your Honors. May it please the court and counsel. My name is Andrew Weiner, appearing on behalf of Multnomah County. This case arose because Multnomah County adopted Ordinance 1311, which prohibits the sale of flavored tobacco products. The county adopted the ordinance pursuant to its authority as a home rule county and local public health authority. Plaintiffs argue that the legislature's creation of a statewide tobacco retail licensing program through passage of Senate Bill 587 preempts Ordinance 1311. The trial court disagreed, dismissing plaintiffs' claims. In Judge Swade's opinion, he wrote that the statutory language in Senate Bill 587 not only fails to support plaintiffs' preemption arguments, it evinces with striking clarity the legislature's intent to allow local public health authorities to enact and enforce standards of regulation affecting the retail sale of tobacco products, including flavored tobacco ban at issue here. Mr. Aiello mentioned that this is not a matter of first impression. Plaintiffs made most of these same arguments in Schwartz versus Washington County, which came before this court last year. The plaintiffs in Schwartz were similarly situated. They were challenging a Washington County ordinance, which, like Ordinance 1311, banned the sale of flavored tobacco products. In Schwartz, though, the parties' roles were flipped on appeal, and this court reversed the trial court's decision, holding that Washington County's ordinance was not preempted. The Schwartz opinion is pending review by the Oregon Supreme Court. However, its conclusions are well-reasoned, and they apply equally here. And I'll return to the Schwartz opinion, but there is an important difference that Mr. Aiello pointed out, and that is that before Senate Bill 587 passed, Multnomah County had a pre-existing tobacco retail licensing program, whereas Washington County did not. So in addition to arguing that the ordinance is itself preempted, plaintiffs are asking this court to find that the county's entire pre-existing licensing program is preempted as well. And the trial court disagreed, and that is the first assignment of error. I want to start on this issue with the timing of plaintiff's lawsuit because it illustrates a weakness in their argument. Before Senate Bill 587 passed, Multnomah County was one of just a small handful of Oregon counties with a pre-existing tobacco retail licensing program. Multnomah County enacted its program in 2015, and that program operated for about 6 years before the legislature passed Senate Bill 587. And in Senate Bill 587, which was passed in 2021, it has a start date, and it was set to start, and it did start on January 1st of 2022. Plaintiffs didn't file this present action in anticipation of the state licensing program getting up and running, or even after it first began. There was no concern about a lack of compatibility between the state's new program and the county's pre-existing one. It wasn't until about a year later, after the county adopted Ordinance 1311, that plaintiffs filed this action. So for about a year, more than a year, plaintiffs operated their businesses under pre-existing Multnomah County licenses without any conflict with the state program. And that concurrent operation between the programs that have continued to date. And they're able to operate concurrently because the legislature included a carve-out for pre-existing programs. And that's made up of two parts. The first is the continuity provision, and that's ORS 431-220, which in which the legislature permits local public health authorities to continue operating and enforcing existing programs so long as they are in place before the cutoff date, and that's the January 1, 2021 cutoff date. And the second piece of that carve out, if you will, is ORS 431A 198 sub 8. And in that provision, the legislature expressly prohibits licensing authorities, that's state and local, from requiring a licensee to hold both a state and local license. So in other words, the statute says tobacco retailers, if you're licensed locally through a continued program, you cannot also be required to qualify for or obtain a state license. So in Owen versus City of Portland, the Oregon Supreme Court describes the framework for determining whether a state law preempts a local law, and it's a question of compatibility. A local law is incompatible and therefore preempted if it can't operate concurrently with state law, or if the legislature intended its law to be exclusive. Because the county's licensing program can and does operate concurrently with the state program, the only remaining question is whether the legislature intended its law to be exclusive. And if looking at the Rogue Valley Sewer System, Sewer Services versus City of Phoenix case, that analysis begins with an assumption that the legislature does not mean to displace local regulation unless the intention is apparent. And more specifically, where the legislature unambiguously expresses an intent to preclude local governments from regulating in the same area governed by state law. And that presumption, there is the presumption against preemption, and it's a high bar to overcome. So turning back to the continuity provision, that's 431A 220, the legislature's intent to preempt is unambiguous in one respect, and that's the cutoff date. So the program needed to be in place before January 1st, 2021. And for those programs like Multnomah County's, the other condition is not unambiguous. It says to qualify, the pre-existing programs need to have enforced standards described in ORS 431A 218 sub 2A. And if you look at that provision, it doesn't contain any standards or qualifications itself. It speaks to subpart B and other qualifications in the state statutory scheme. And what the plaintiffs are arguing is that if we read these together, the legislature intended that all of the standards and qualifications for state licensure, that must be the floor for continuation of a pre-existing program. So in other words, the argument is, well, local governments must have had all of those standards and qualifications required for state licensure in place already. And the trial court disagreed. And here it's the timing of the legislation that kind of exposes the flaw in the argument. Senate Bill 587 wasn't enacted until June of 2021. So that's 6 months after the cutoff date. And Mr. Aiello mentioned the fortune-telling requirement portion of Judge Swade's opinion. What he says is the plaintiff's reading of this would have required local public health authorities with pre-existing programs to have predicted in advance the standards and qualifications that the legislature would ultimately choose more than 6 months after the cutoff date. So if you look back at that provision, though, 431A 218 2A, in the context of the entire scheme, the state's entire licensing scheme, you can get a better understanding of the intent. And that is that the cutoff date, having a program in place by the cutoff date was enough. You didn't need to perfectly align with the standards and qualifications of the state license. And that's because subsection 2A addresses the scope of permissible local regulation statewide. So that means for localities with programs and without existing programs. In both cases, a local public health authority is permitted to enact and enforce standards and qualifications for licensure that best serve the needs of their respective populations. So localities using a state licensing.
What's to stop a local government from deciding that their population doesn't require the level of standards that the statute provides for and simply includes one sort of weak sauce standard, and that's it? but it had been in existence at the statutory cutoff date.
The pre-existing program, yeah, and I think that's fine, Your Honor. The statute doesn't disallow that. It basically says, hey, if you already have a program in place, you can continue to enforce the standards and qualifications for your licensing scheme. If you don't, if you're like Washington County, you have to use the state standards and qualifications. But that same provision says you can add additional ones if you want.
So how is that consistent with the legislature's intent to regulate this sphere if a county could have very, very little standards and have their licensure be the only licensure?
Well, the idea of the state program is to regulate and set up qualifications for licensing. So if you're going to have a state license, if you already have a licensing program locally, which a few counties did, and the legislature did consider that, folks from different counties spoke about their programs. They talked about their specific interests, and there was a discussion about what would be allowed or disallowed. For example, the pharmacy exclusion, which was an express preemption in the statute that says you can't have local ordinances, localities can't pass ordinances that disallow tobacco from being sold where pharmacies are located. And that was specifically exempted, disallowed. So because the standard says, hey, unless it's specific, express, and unambiguous, we don't preempt localities from enacting and utilizing and having programs and ordinances that meet the needs of their specific populations. And if you look at the legislative history, the staff measure summary for the Senate Bill 587, it describes the state program's intended operation. And that's to allow local public health authorities to enforce local standards of regulation or to enforce state standards rather. And while discussing how to handle programs that were already in place, like Multnomah County's, during a meeting of the Senate Committee on Healthcare, Senator Knott commented that localities with existing licensing programs would want to keep them, and the legislature didn't want to preempt those existing programs, which is why the continuation clause was added. If you consider the language itself and the legislative history, the trial court was correct in its conclusion that there is not an express and unambiguous intent to displace Multnomah County's program in total because it existed prior to the cutoff date. The second assignment of error is a direct challenge to Ordinance 1311. And the preemption analysis on this issue begins with the same general rule as the first, and that's the legislature's preemptive intent must be express and unambiguous. And that's just absent from the statutory text. In fact, the statute expressly permits local public health authorities to enforce standards for regulating the retail sale of tobacco products, in addition to those prescribed by state law. And in this instance, the ban on tobacco products containing flavor ingredients is just such a standard. It's really no different than a ban on tobacco products containing any other ingredient deemed harmful for purposes related to public health and safety. And if you look at the text more broadly, the absence of legislative intent to preempt a local ban, it's even more apparent. And I would direct the court to look at ORS 431A 218 sub 6A. There's an express preemption on the pharmacy having a retail sales in the same location as a pharmacy, which I alluded to a moment ago. And it's that kind of express preemption that demonstrates the legislature knows how to do this. If they wanted to prohibit flavored, disallow prohibitions on flavored products, they could have included that. And there was discussion during consideration of this bill about the likelihood and the interest of counties passing flavor bans. So it was known to the legislature that this could be coming, and they certainly could have included it. They chose not to. The state licensing scheme does not require licensees to sell any particular product type. So the county's enforcement of the flavor ban in Ordinance 1311, it wouldn't conflict with the operation or enforcement of the state program at all. And, this court, as Mr. Aiello mentioned, heard all these same arguments in Schwartz versus Washington County. They apply here equally, and the court should issue a consistent opinion with Schwartz. And for plaintiff's third assignment of error, they argue that the trial court should have found that Ordinance 1311 violated Article 6, Section 10 of the Oregon Constitution, which provides a county charter may provide for the exercise by the county of authority over matters of county concern. Multnomah County is a home rule county. Its charter provides that authority, and the regulation of tobacco products related to public health and safety is a matter of county concern. Passage of Senate Bill 587 didn't transform issues related to the health impact of these products into solely or even primarily matters of state concern. In any event, that's not the test. In Thunderbird Mobile Club, LLC versus City of Wilsonville, this court explained that trying to determine whether an issue is predominantly of statewide or local concern is political, not a judicial determination. Instead, the question is whether a local law is displaced by state law. It depends on whether the laws are incompatible. And for the reasons I've already discussed, the county's flavored tobacco ban is not incompatible with the operation of the state's program. And finally, at least in briefing, plaintiff argued that Senate Bill 587 limits the county's authority to like a ministerial function, and that's mistaken. Just the fact that the statute directs local authorities to be able to enact their own rules demonstrates why that's incorrect. So consistent with this court's analysis and conclusions in Schwartz, Multnomah County asks this court to affirm. Thank you, Your Honors.
Great. Thank you for the argument. Mr. Aiello, we're ready for your rebuttal. Sorry, we can't hear you.
I'm going to rattle off some case law here. I'd be happy to introduce it in a memorandum of additional authorities, but part of the problem with the ingredient analysis from Schwartz is that it introduces the issue of potential federal preemption. 21 USC section 387 A2A would be the federal statute. RJ Reynolds Tobacco Co. v. County of Los Angeles 471 F sub 3D 1010, California 2020, and U.S. Smokeless Tobacco Manufacturing Company LLC versus City of New York 708 53D 428 Second Circuit 2013. All of those, both of those cases declined to consider a flavored tobacco prohibition as a restriction on ingredients to avoid federal preemption. Additionally, looking at a license, counsel argued that a license does not essentially entitle a state licensee to sell any particular type of tobacco. A license grants, quote, permission to act, end quote, and is a, quote, permission granted by competent authority to engage in a business or occupation or in an activity otherwise unlawful, end quote. Wang versus Department of Revenue, number TC-MD 150422C 2016, Oregon Tax, Lexus 90, and that's at note 3. More to the point, a license, quote, a license is a right or permission granted in accordance with law to engage in some business or occupation, to do some act, or to engage in some transaction, which but for the license would be unlawful, end quote. That's Chamber of Commerce of the United States versus Whitting, 563 U.S. 582. The pen site is 593, and that's a 2011 case. As for the express preemption issue when it goes to licensure, I agree. 218 subsection 6A contains express preemption, and it's the exact same language that the legislature used in subsection 7. It says that a city or local public health authority may not require a person to hold a license issued by the city or the local public health authority, except as provided in ORS 431.220. And so that's where the express preemption is. It's in 218 subsection 7. I agree with counsel. 6A has the same language in it. Turning to the issue of Ordinance 1311, ORS 431A.220 not only provides that the county can continue to enforce its license, but can continue to enforce its standards. So to the extent that this prohibition on flavored nicotine products is even a standard, which was, as Judge Tukey, as you know, was at issue in Schwartz. If it is a standard, it goes away with the licensure, and that's what 220 says. So we still have the issue of the January 1, 2021 cutoff. Senator Nope in legislative history says that these counties may have gone further than the state. There's nothing in the legislative history to your point, Judge Kamens, that a local public health authority be allowed to require a lower standard than does the state. And that's consistent with the IGA that defendant signed. Again, here we're dealing with the plain text of the statute, and essentially defendant doesn't like what the plain text of the statute says. Our brief, we cite Cole versus Farmer Insurance Company. Quote, if the legislature has chosen language that creates unexpected and unintended results, the legislature can amend the statute to express its actual intent. It is not the function of a court to insert language that should have been added or ignore language that should have been omitted. Essentially, defendant wants to take out the citation to 218 subsection 2A, but it's in there, it's in the plain text, and I've run out of time.
Thank you for the argument. That was helpful. That case is submitted and we're ready for our final case for the afternoon.
Thank you, Your Honors.
Thank you, counsel. I'll go ahead and move you down to the attending position. Feel free to leave them there. And the counsel for the next case.